Good afternoon, everyone, and welcome to the Committee for Justice's virtual panel discussion, The Common Purposes of Antitrust and Intellectual Property. I'm your host, Ashley Baker, and I'm the Director of Public Policy at the Committee for Justice. I'm now going to introduce the panelists in the order in which they will be speaking. Seth Cooper is Director of Policy Studies and a Senior Fellow at the Free State Foundation. His work on federal communications and technology policy at the Free State Foundation began in 2009. Mr. Cooper previously served as the Director to the Telecommunications and Information Technology Task Force at the American Legislative Exchange Council, or ALEC. Mr. Cooper served as a judicial clerk to the Honorable James Johnson at the Washington State Supreme Court. He has worked in law and policy staff positions at the Washington State Senate and at the Discovery Institute. Mr. Cooper is a 2009 Lincoln Fellow at the Claremont Institute. With Randolph May, he is co-author of Modernizing Copyright Law for the Digital Age, Constitutional Foundations for Reform, and Constitutional Foundations of Intellectual Property, a Natural Rights Perspective. Mr. Cooper earned his BA degree in political science from Pacific Lutheran University and received his JD from Seattle University School of Law. Kristen Jacobson Asinga is the Austin E. Owen Research Scholar and Professor of Law at the University of Richmond School of Law. She teaches and writes in the areas of IP, patent law, law and language, and legislation and regulation. Her recent scholarship focuses on patent eligible subject matter, patent licensing firms, standard setting organizations, patent law reform, and claim construction. Professor Asinga received a BS in biomedical engineering from the University of Iowa, and an MS in electrical engineering from Southern Illinois University, and a JD from the University of Illinois College of Law, where she graduated magna cum laude. She practiced at the law firm of Finnegan, Henderson, Faribault, Garrett, and Dunner LLP, where she did patent prosecution and litigation. She then clerked for Judge Richard Lynn of the Federal Circuit. After clerking, she entered academia, teaching first at the Chicago-Kent College of Law and then at the University of Richmond since 2006. So the brief presentations by our two panelists will be followed by a discussion, and then after that, we're opening up the floor to Q&A. However, if you look at the bottom of your screen at the Q&A function, you can submit a question at any point throughout the course of the panel, and I will just kind of weave that into the discussion whenever it makes sense. So feel free to just go ahead and send me any questions you may have, and I will try to get to as many of them as I possibly can. And with that, Seth, the floor is yours.
Well, thank you, Ashley. Thank you to the Committee for Justice for inviting me. I'm here talking about a subject where I think it's kind of a matter of common sense to anyone who will reflect on it. We see this, I think there's a clear distinction, of course, between copyrights and bad monopolies, but you kind of see a recurring occasional drive-by attack made on internet websites and stuff, including by smart and very thoughtful people that treat copyrights as a kind of, like I said, illicit or bad monopoly. I recently wrote an article, and I've written in the past with my colleague, Randolph May, the Free State Foundation, sort of about the property rights basis of copyright. And that was what the founders understood. They understood copyright to be a type of property right, like any other property right, grounded in a person's natural right to the labor, the fruits of their labor. So copyright doesn't create, the government doesn't create anyone's creative work. That comes from the author, the creator themselves. The law comes in, the law of property or law of copyrights, to protect the exclusive rights of the creator in manufacturing copies, in distributing copies, and more recently in transmitting that work to the public or publicly performing it, or being able to prepare derivative works on it. And this is consistent with the founders' view of government in protecting property, and also very importantly in protecting the ability to acquire property, because copyright is limited in scope. It's focused on not ideas, but particular expressions of ideas, investment and ingenuity in particular ideas in the product. And so with that narrow focus, it leaves the field wide open for any other creator to come along and do likewise and create their own creative work and put it to market. And so that's, again, very important. And what happens with this criticism against copyright that's unfounded is you'll see the expression of it's a monopoly in ideas. It's very well established in copyright law, of course, going way back, Ideas, abstract thoughts can't be copyrighted, just like facts can't be copyrighted. And we call that doctrine the idea expression dichotomy. It's been recognized for a long, long time. And the founders, in some rough sense, perceive this. And the first Congress, of course, enacted the Copyright Act of 1790. They were a group of people who were still well versed with the ideas of bad monopolies. They were not long previous fought a war against a nation that had very much something to do with monopolies, East India Company and things like that. And so, and even in the copyright realm, there was this backdrop in Britain. There had been, at least until the early 1700s, of a monopoly in printing with the Stationers Company. And the founders didn't have anything to do with that. They rejected that. They adopted the free press approach, including drafting the First Amendment. The same Congress that passed the first Copyright Act, proposed the First Amendment with liberty of the press. So they understood that distinction, and that grew over time as thinkers and statesmen began to be worried about not only just government bestowed monopolies, that there was still a clear distinction. So when you got into the Jacksonian era, that concern with monopolies was very much present, but that was an era in which copyright was expanded at the same time. And I think it suggests that these people saw a common sense distinction, and that continued into the Centennial Congress, the 100th Congress, which established the Sherman Act in 1890. Turned around in the next session, they passed the International Copyright of 1891. So I think does a disservice to these people to think that they couldn't see some plain common sense distinctions between property rights and kind of bad monopoly rights. The water was muddied a little bit later on in the 20th century. Of course, you had the Supreme Court started to become very skeptical of intellectual property rights in some ways, and ways that I don't think made much sense. And this certainly carried over. It was mostly, I think, in the patent context, but it did spill over to the copyright context as well. So you have a decision like U.S. versus Paramount Pictures in 1948. The Supreme Court treated resale price maintenance and tying arrangements with copyrights as at least presumptively bad. And it took a while for that to go away. And it did, more or less, thanks to the 2006 decision by Illinois Tool Works versus Independent Inc. That's where the Supreme Court said, no, we're not going to treat tying arrangements involving a patented product as presumptively an exercise of market power anymore, or we're not going to treat the ownership of a patent right as presumptively conferring market power. That same logic, of course, applies to copyrights. And what it really comes down to, a lot of this discussion with copyrights and monopolies is really, again, a loose use of the term monopoly. When the term has been used in the past to refer to copyrights or even patent rights, it's really conveying the sense of personal ownership. And if you were to treat the idea of a copyright as the same thing as a bad monopoly, then anyone's ownership of any property is going to be a monopoly. And I think that's pretty absurd. So, this isn't super academic stuff. I think it's a very common sense, straightforward matter. But copyrights are property rights, and they're not simply government giveaways. Government's there to help secure them, and the exclusive rights that we recognize in those. But again, it leaves the field wide open for anyone else to come in and to challenge that. And there you have it.
Okay, I guess I'll jump in. So I will play a little bit off of the article that Seth wrote and talked about, but I'm going to talk about patent law, which is different than copyright law in a number of respects. And also I want to play a little bit with the idea of monopolies as he described them. And I'll explain that as I go through. So patents are also, just like copyrights, property rights. And we think about patents as granting limited monopolies, which may give rise to some of that confusion that Seth said, where people are loosely throwing the word monopoly around when they're talking about intellectual property. But because a patent does grant a limited monopoly, that's not a terribly surprising thing. It's just wrong. So patents do give the owner a grant of exclusive rights, which keeps other people from doing certain things, making, using, selling, offering for sale, the subject matter of a patent. But it's limited in time. So it's limited to 20 years from the date of filing. And after that, the technology goes into the public domain and everyone is happy. There's supposed to be some positive aspects to patents, right? And to granting of property rights in patents. So it's the ideas are we are encouraging people to invent things in order to obtain a patent. We're encouraging them to use and put on the market the things that are patented, or what I like to call innovation. And we're also encouraging people to make disclosures through their patent documents so that the science is made publicly available. So we have these good things that are tied into the idea of granting a patent. In patent law, unlike in copyright law, we don't have the idea expression dichotomy because actually patents are intended to protect ideas. The whole point is to protect ideas. That's what an invention is. But unlike copyright, there is a rigorous examination process before a patent is granted. Now, some will say that the examination process isn't rigorous enough, and that's certainly a topic for a different day. But patent applications are examined to determine that the invention is useful, that it is new, that it is not obvious, and that it is clearly and adequately disclosed before a patent is granted and that limited monopoly kicks in. Also, you can lose your patent if it is determined after the patent is granted that it fails one of those requirements: usefulness, novelty, non-obviousness, disclosure. Okay, so it's different from copyright in those respects. So what I want to move to now, in the last part of my remarks, is how this intersects with antitrust law. And the way that I like to talk about it in a very simplified, non-academic way, talking to largely my 2L students oftentimes, is that both patent law and antitrust law are focused on, at least in part, promoting innovation. And innovation meaning getting more and new products out to the people so they can have them. And both antitrust law and patent law do this, but they do it differently. And so in many instances, a patent itself does not confer market power. And that's a really important place to start from when we're talking about the intersection of antitrust law and patent law. So just as a simple, quick story to tell you, a few years ago, my family bought me a sports watch, a Garmin. It was nice. And I opened up the box, and sitting right there on top of my watch was a piece of paper that listed 37 patents that covered my watch. And that'd be great. And you're like, wow, that's really amazing. Garmin must be the only people who can make GPS-based watch. No, they're not. They're not. There are so many other companies. There's Coros, there's Suntos. Don't get me into it. I'm a kind of a big runner geek, and I really love sports watches. But anyway, the point is that the fact that one company has 37 patents and then some on a single product doesn't stop other companies from also making that same product and competing on the market with a similar product that has different features, that some of which are better. In fact, I'm eyeing a different watch that lasts longer, but that's okay. Anyway, so it doesn't confer market power necessarily, a patent. It encourages other companies to design around, which is exactly what we want from competition. So that's a good thing. Additionally, the old saw from antitrust textbooks that, monopolies are not bad if they're earned through excellence, acumen, and innovation. Well, that's precisely what patents are: excellence, acumen, and innovation. So as I'm wrapping up, before I turn it back to Ashley, I do want to point out 3 places in modern policymaking, current events, where we kind of run into a wall where it's more easy for people to say, well, patents must be bad because they create monopolies. And so the 3 places I want to point to are pharmaceuticals, standard setting organizations or standard development organizations, and patent licensing firms, because those are really the 3 places right now, at least, where there seems to be some sort of intractability. I don't agree, but seems to be, at least in some policymakers' minds, an intractability between patent law and antitrust law. So first, pharmaceuticals. One thing to know about pharmaceuticals is this. When a patent is granted on a pharmaceutical, yes, that does indeed create a monopoly over that particular composition for a limited period of time. But there's two things that are happening on the back end that I think get a little less play than, oh my goodness, one company owns that patent. So first of all, there's a ton of competition happening at the front end of pharmaceuticals. Okay, there's a race in a number of cases in order for there to be development of drugs. That's competition. That's good. Now, people may talk about whether or not races are wasteful, possibly, but there is this idea that there's competition at the front end. Second of all, we need to provide some incentives in the pharmaceutical field in order to get over the cost of invention and the regulatory standards that are required in order for a pharmaceutical to actually make it out to the people. So we definitely need to provide the patent incentive in order to get the innovation. There is competition happening at the front end. And then at the back end of it, there's some competition too, because of the Hatch-Waxman Act and the ability for generic companies to challenge issued patents. I'm not going to get into the pay for delay issue, but it's important to recognize that even in a place where you're like, well, you know, there's not a whole lot of design around for one particular drug, there is some there's extensive competition, and there's also a need for the incentive. Second place where we run into a tough wall between patents and antitrust is standard essential patents, or those patents that are covered by standards. And similar to pharmaceuticals, I just want to point out that, you know, there's an awful lot of competition happening at the front end before the standards are set, right? So the way that standards are developed, just in the quick and dirty rundown in 10 seconds or less, a bunch of companies submit their technology. It is vetted, argued about, altered, reiterated over and over for a number of years before the best possible solutions arise out of that pile of patents that a number of different firms submitted. Okay. And so there's a lot of competition at the front end. There's a lot of need to incentivize this development because there's an extraordinary risk, right? If a company submits some technology for a standard that isn't ended up being picked, well, then they're not part of the standard. They spent all this money developing a technology that now nobody's going to use. So we have the competition, we have the need to incentivize it because of the risk. And also there's just not a whole lot of evidence that standard essential patents are being used in anti-competitive ways. Now, despite all this, Commissioner Slaughter has said on more than one occasion that SEPs convey extensive market power. The evidence from a lot of empirical work that's being done right now, and some really nice articles and research being done, is really no. And then finally, last quick before I give it back to Ashley, is patent licensing firms is another place where we run into that little snag between patent law and competition law. Some people like to call these patent trolls. I don't. I call them patent licensing firms because I think that more adequately describes what they are doing. And so the reason we need to have patents in these cases is because the patents actually facilitate licensing. It allows companies that fail to have an exit strategy because they can sell their patents then to somebody else who can use them. It creates relationships and collaborations and makes those things possible. And so patent licensing firms are not necessarily all bad. Some of them have bad behaviors, but the existence of a patent licensing firm and their using of patents is not an anti-competitive thing necessarily. So there's my time, and I'll turn it back to Ashley.
Thank you, Kristen and Seth. I'm now going to take a moment or two to kind of go over a little bit of the antitrust context, the broader antitrust debate that's happening right now, and a little bit of the history as well, since I focus more on antitrust, maybe fill in some of the gaps there in terms of why some people think that these are in conflict, although they're really not, and where these arguments are, where we're seeing these legislatively as well. So as you all know, we have this issue right now with in Congress. The House is investigating the 4 tech companies. They came out with a report that was just passed out of House Judiciary Committee. At the same time, we have 4 different lawsuits from Coalition of State Attorneys General. We have one from the FTC, we have one from the DOJ, and there's also a bill in the Senate, among a lot of other things. So there's a lot of discussion right now going on around the antitrust debate and around competition more generally. And as Seth was pointing out, people are playing fast and loose with the term monopoly or monopolization, which, as Kristen pointed out too, is not not illegal. And Justice Scalia said that very clearly in Trinco, by the way, that having a monopoly is not in and of itself an anti-competitive harm. But where this is kind of getting really muddled is when it comes to larger tech companies. And it really doesn't make much sense, because if your concern is competition, actually patents are one of the greatest anti-monopoly devices that have ever been created. So it allows a single inventor, usually someone who's just entirely out of left field, someone who's not with the industry, not with a large company, to come in and disrupt the entire industry with a property right in a new innovation. And this, adds more competition to the markets. And it was very clear that this was that when the Sherman Act was passed in 1890, that the same Congress, as Seth pointed out, passed the International Copyright Act in 1891. So the fact that these two concepts are not mutually exclusive, or there's not tension between the two, it's very clear that it's not a restraint of trade. There was about a century of debate over what the term what restraint of trade really meant in the text of Section 1 of the Sherman Act, because under Section 1 of the Sherman Act, so from about 1890 to about 1917 or so, you had this period in which, under the plain reading of the text of the Sherman Act, pretty much everything's illegal. Any sort of business contract is acting in restraint of trade by definition. So like shoes sold in pairs, anything that you can possibly imagine would be illegal under that text. However, there was a certain meaning of it at the time that Congress had intended. And they also intended for antitrust law to be developed through the years through judicial interpretations in a common law type manner. So that's how we got from 1890 to where we are today, in a very kind of painful, long, drawn out manner, as we had this period of antitrust law that was pretty misguided up until about 1960s, and it's been relatively stable since about 1977. And before that, you had Robert Bork with the antitrust paradox, in which he identified the consumer welfare standard, which is the set of principles under which antitrust law currently operates. It's the standards and underlying legal standards and things that guide litigation, and describes the ultimate goal of antitrust law, which is that antitrust violations don't just harm competitors. That's how the system worked kind of more in the EU and the United States. Antitrust violations harm the consumer through harms to the competitive process. So that's all under the consumer welfare standard, and Robert Bork's work and kind of the Chicago school of thought that it led to, and that preceded it as well. And during that same time, between about 1920 and 1960, you had, with the Supreme Court, as Seth alluded to, there was a bit of a murky period in intellectual property law as well, which it took until about 2006 to clear up. But you had this you had both of those at the same time, and antitrust law is particularly unmoored in the 1960s, although it took approximately 1 year after the publication of the Antitrust Paradox, which is back in publication on Amazon, by the way. You can now read the Antitrust Paradox. It went out of publication for a few years, but if you haven't read the Antitrust Paradox, here's my pitch for grabbing a copy on Amazon. Anyway, during that period, so it took the Supreme Court a year after the Antitrust Paradox was published to explicitly identify the Sherman Act explicitly as a consumer welfare prescription. And then, the law was kind of built from there. So a lot of the proposals that we have today really take back the past 45 to 50 years of antitrust law and do a complete rewrite of that. So the more extreme proposals do, such as one specific bill that we see in the Senate right now, such as the 451-page House Judiciary Committee report, which basically overturns, I think, 20-something Supreme Court precedents related to antitrust, which is pretty much as many as exist. It is a complete rewrite instead of more of a tailored solution. And it's all, supposedly towards these digital platforms. However, it would affect the entire economy. And one way to, if you're concerned about the power of these platforms, antitrust is one tool in a larger toolkit. And enforcing intellectual property rights is another one. And a weakened IP system certainly is not helping the case. But it's very interesting that those who were making these sort of neo-Brandeisian arguments again, that let's use antitrust for populist causes, are also arguing that we don't need strong IP rights. This is really counterintuitive. They also have a lot of misconceptions when it comes back to just describing the founding and what role the founders thought of the monopoly, the anti-monopoly underpinnings of our founding, and the intellectual property rights underpinning, which we found in the Constitution, whereas there were other counterbalancing measures against monopolies, but it was not explicitly articulated. And one of those counterbalances were, as Seth alluded to in the First Amendment, there was concerns at the time over the printing press. So we've seen this kind of push and pull over the years between these two sides of the debate, but really at the end of the day, intellectual property really fosters competition, and it's something that empirically we've proven now also leads to more market entrance. So I'm going to leave the rest of the discussion. We have quite a bit of I'm sorry. We have quite a bit of questions here. The first one, though, is about, and I'm going to go ahead and get into the questions instead of a broader discussion, because I think we're probably going to cover this stuff anyway. But one says, but the founders put useful arts, for example, maps, not songs, and poetry, and originally had copyright lasting tens of years rather than close to a century after the death of the creator. So I think this question is getting to what is Congress's role in amending or revising copyright statutes.
Well, I mean, can you get the question there? Is it what's Congress's role? I mean, Congress has a pretty wide open role, if that's what you mean. I
think maybe to ask why is that the case? I was just adding that this is related to Congress's role in amending our IP laws. Sorry for the confusion.
I think that's just a provision in the Constitution of 1787 that actually expressly protects individual rights. And I think also is interesting is that it uses the word secure intellectual property rights. And this is consistent with the idea of a Declaration of Independence, that your rights in these things don't ultimately originate from government itself, that it's connected to the creators or to the inventors in their own way, define in particular the scope of and terms for those and sort of the rules. But that's what it is. It's a pretty broad grant of authority. And if you go to the trademark cases by the Supreme Court in 1879, particularly with the copyright, it refers to the intellectual property clause, which talks about writings. And it sort of reflected the widespread view that this was to be broadly understood. The quote was, "The writings which are to be protected are the fruits of intellectual labor, embodied in the form of books, prints, engravings, and the like." So we don't need to be tied. The founders' views are important. They set the principles. They provide some good examples. We're not tied, though, to a wooden literalism. So if we develop new media, there's no reason why ebooks can't be protected like printed books. And there's no reason why other sorts of media can't be involved. And that's essentially the reason why we have Congress there. We can't always anticipate how these new media are going to develop. And so they're there to sort of update the law and match it to the technology and the advances as they come about.
This is kind of my own follow-up question, but every time that Congress has really amended the Copyright Act, they've acted to strengthen it in light of new innovations. What do you think that says overall?
Well, we certainly have more means of preserving goods over time. And I think that's just really reflective of the fact that you have a constitution. You're coming right in the area where we hadn't even quite gotten to the Industrial Revolution. And it's very, very difficult just as a macro historic matter, for people to preserve wealth and accumulated stuff over time, things would just degrade and erode and get ruined. So, as we industrialize and we advance and certainly move to the digital age, we're able to preserve property, and we're able to keep records of these things a lot better than we were able to in any times past, able to index these things. If we modernize the Copyright Office further, they could probably do more in that regard. And I actually think that even the lengthier, this often comes about in the attack on copyright as a monopoly, I'll just say, comes about in the larger debate over copyright terms and what's the optimum amount of terms, and whether or not they should ever be extended, or comparing what the terms are today to what they were in 1790. I don't have definitive views on what the best maximum optimum term is, but I'll just simply say that the idea of a lengthier term is consistent with the founders' idea of property rights too. It's not inconsistent. They certainly believe in the idea that you would have property and you'd want to pass it on to your children, or be able to, or the fruits of that. And so I think a lengthier term than 14 years or whatever, or 28 years, is certainly fine. And we saw it's always increasing as time goes by. And certainly the founders were kind of around on the scene when the Copyright Act was expanded. Certainly Noah Webster was. And so I think that's fine. You just got to make a best judgment, and that's what Congress needs to do, and make a common sense of where we're at and where the technology's at.
And before the next question, I'll add in some of the specific proposals that are out there in Congress right now, and kind of what they say that would harm IP. The one that I referred to that's in the Senate, that's the bill that's sponsored by Senator Amy Klobuchar, and it has it's a very overlooked clause in that, and it's a very expansive bill. And there's one particular clause of it that says that applying for enforcing a patent, trademark, or copyright will not itself be considered exclusionary conduct, but it can be considered part of a course of conduct that is used to establish exclusionary conduct, which means, essentially the same thing that I just said. So that would have a really chilling effect on, even applying for intellectual property rights, if later that can be used against you, when antitrust is weaponized against you in that sort of hypothetical scenario. It adds a lot of uncertainty to the mix. So our next question is question for Professor Asinga. What is your opinion of patent thickets surrounding therapeutic biologic agents such as Humira? The Humira patent thicket has successfully prevented any biosimilar agents from entering the US market. Do you consider patent thickets in this context to be anti-competitive? A case on the Humira thicket is now before the Seventh Circuit.
Okay. First, can I react to what you just said, Ashley? When you mentioned that provision in the Klobuchar bill is often overlooked. Whoa, that was like the first thing that jumped out to me. Like, that wasn't overlooked. That was like front and center. This is really bad news that applying for a patent could be a potential like evidence in a piece of anti-competitive behavior. I'm like, wow, that's like possibly the worst thing that could ever happen.
Not enough people are talking about it, though. I testified in front of the Senate Judiciary Committee and talked about it, so she's heard it from me at least.
Yeah, no, it surprised me when you said overlooked, because honestly, like you could have put marquee lights around it as far as I was concerned. It was huge. I'm sorry. So I will now go to the question you actually wanted me to answer. So patent thickets. I don't think patent thickets are in and of themselves anti-competitive, just like I don't think patent trolls in and of themselves are anti-competitive, etc. I think it's more important when we're thinking about anti-competitive behavior to look at the actual actions and the facts. So part of the problem with patent thickets, and so the idea of patent thickets is that there's multiple overlapping patents that cover a territory so that people can't squeeze in. You can't see what I'm doing with my hands right now, but yeah. And so the idea is that really shuts down competition, because there's no space for a competitor to get into there. And there's two kind of things going on there. First thing about it goes back to the idea of patent examination. as I mentioned at the beginning of my remarks, the idea that patents are examined by the patent office before a patent is granted, and they are supposed to be on new and non-obvious inventions, meaning that if the patent office has granted a number of overlapping patents, that's possibly a problem in the patent examination, and that they're granting patents on things that aren't new if they're overlapping too terribly much. That's not an anti-competitive problem. That's a problem that the patent office needs to fix. So that's one issue, is that where we see patent thickets, sometimes what we're seeing are patents that maybe shouldn't be granted or shouldn't be given the scope that they've been given. The second thing about patent thickets and their enforcement is that the drugs are also going through the FDA process, right? The biosimilars and the drugs are going through the FDA process. The FDA process is supposed to be approving drugs that are new. And so there's a regulatory hand on one end of the scale at the patent office. Somebody is saying, yeah, this is different enough from everything else that's being done. You have the FDA who's granting approval to these pharmaceuticals and biologics, that's saying, yeah, this is new and different enough. And then we still have people out in the policy space and out in the litigation space saying, no, these are not different enough. They're not letting us in. They're covering too much territory. And so one thing that this might signal to me is this idea that maybe the problem isn't in competition law, but possibly in one or the other end of the regulatory spectrum. The other thing I want to say about patent thickets is this, and this is possibly an unpopular viewpoint, but incremental innovation is normal, it's expected, and it's oftentimes the most fruitful. I know that the theory just in general has kind of been like debunked or disfavored, but the Edmund Kitch prospector theory of intellectual property, right? You're going to be the most productive panner for gold if you just scoot down the river a little bit. That's like a really, really bad retelling of the prospector theory. But anyway, the idea of incremental innovation, I think, is not given the power it should be given in the intellectual property story. The companies that are improving on what they've already invented, I think it's fine to continue to give them patents in that space because they've worked really hard and they've gotten there. And so I find incremental innovation to be to the extent it passes the hurdles on one end or the other of the regulatory spectrum. I think that incremental innovation actually doesn't create a problem and isn't anti-competitive.
Regarding that specific case and the Seventh Circuit, just to rant a little bit, I would say if you really want to try to read some tea leaves, maybe go back and scrutinize some of Judge Diane Wood's testimony in front of the House Judiciary Committee about a month ago, in which she talks about antitrust and intellectual property, which, as someone who cares a lot about judicial activism, I found to be a bit inappropriate and definitely an opportunity for some opportunistic future litigants who want to, like I said, read the tea leaves there in a matter of ongoing litigation. I think there's a 10th Circuit case that is a little bit similar, or is that something different? Okay, maybe not. I know there's a pharmaceutical related case in the 10th Circuit, but I have not been tracking the lower court cases. So speaking, let's see, we have that one. Kristen, can you talk a little bit about FTC versus Qualcomm, and maybe can the two of you talk a bit about agency authority over antitrust and intellectual property and how that works both domestically and internationally?
Well, I'll jump in and take the FTC if Seth wants to jump in and take the agency. I don't want to take all of the answers to the questions. So the FTC versus Qualcomm is an interesting intersection of patent law and antitrust. Just in a quick rewind for those who weren't paying attention, 2017, right before the shift in administration, the FTC, over objection, filed a complaint alleging anti-competitive behavior. by Qualcomm due to its no license, no chips, as it is popularly called, policy of how it chooses to license its chips. And so the FTC said it was anti-competitive. Judge Lucy Koh out in the Northern District of California wrote a very long and very detailed opinion that basically said, yes, it was anti-competitive, that it was charging an unfairly, unreasonably high royalty rate, that I hesitate to jump in here because I know it might set off Ashley's alarm bells, but that Qualcomm has a duty to deal with its competitors. Those were the two main points. And then issuing this sweeping injunction. So then it gets appealed to the Ninth Circuit by Qualcomm. Interestingly enough, the Department of Justice intervenes on behalf of Qualcomm. So you have a really interesting dynamic of the FTC versus the DOJ on antitrust issues at the Ninth Circuit, which was pretty cool to see. And the FTC did kind of drop basically the duty to deal argument before it went to the Ninth Circuit, but still was making a strong argument that Qualcomm was charging unreasonably high royalty rates without a whole lot of evidence that they were unreasonably high. And so the FTC lost at the Ninth Circuit. They sought en banc review by the Ninth Circuit. The Ninth Circuit denied it. And then no cert petition was filed. So the case is final. Qualcomm won. And that's kind of the quick overview. But I'll let Seth talk for a while.
Sure. The Copyright Office's role regarding copyrights is far more limited, I think, than the Patent and Trademark Office. One of its main functions is simply having a recording function, and so it's more of a ministerial operation in that respect. It does have some limited rulemaking authority, but it's very limited. Periodically, they will establish rules for exempting certain kinds of things from Section 1201 of the Copyright Act that came through the DMCA, having to do with, my mind's blanking right now, but there's very limited rulemaking functions, and it was basically have a limited fair use kind of power that it can grant certain exemptions from copyright prohibitions in a very narrow circumstance. So it does have some sort of executive functions. It's kind of a strange anomaly, but it's sort of by historical anomaly, got tied into the Library of Congress. So it's actually housed within the Library of Congress, which is a very interesting thing in itself. Partly it had to do with an initial requirement for getting a copyright was you had to submit a book deposit to get a copyright. And so that helped build up the Library of Congress by people making book deposits. And so that's still where it's at now today. And another function it has, of course, it houses the Copyright Royalty Board, which sets rates for certain types of royalty rates for sound recordings or for songwriting artists and different things of that sort. And then aside from that, a new thing, of course, is the Copyright Office, is now overseeing the implementation of a new small claims court. And this would be a matter of a voluntary venue where copyright owners who are aggrieved could have their matters taken to the Copyright Office or a tribunal set up, kind of like a small claims court. Both sides have to agree to be there, and it would have just sort of a limited and small claims ability to offer a decision, and that could be enforced in federal court. It hasn't happened yet. It's still in the setup mode, but Congress just recently authorized it to undertake this. So we'll see how it goes. I think it's worth a shot. And so I'm interested in seeing that as well. It can certainly save copyright owners of modest means a lot, because getting a lawyer and going into federal court, most of the time, the economics simply aren't worth it for many copyright matters.
Interesting. So when Kristen said set off my alarm bells regarding duty to deal, I'll take that opportunity to point out that one of the also really terrible proposals that is being seen out there kind of across the board, both in the House and the Senate, and you see pieces of it in litigation too, like in the Qualcomm case and also in some other FTC related claims, is is refusal of the deal law, or a revival of what they call the essential facilities doctrine. And the House Judiciary Committee report specifically, and this is not specifically an intellectual property issue per se, it's more broadly a property rights issue. You've never had a duty to deal a creation to your competitors, whatever your invention or property may be. So this is kind of a broader core property rights issue as opposed to specifically patent or copyright or what have you. But the House Judiciary Committee report called on Congress to override the two governing precedents, Trinko and Linkline, and revive what is known as the essential facilities doctrine, which never really completely existed to begin with. If you read, I referenced earlier Justice Scalia's opinion in Trinko, which I would really suggest reading to get some more context on that, in which he describes why refusal to deal is at the outer boundary of Section 2 liability for a good, appropriate reasons, because you have no obligation to deal something to your competitors that you've created through the fruits of your own labor, and that's how it's a broader property rights issues. So speaking of proposals that are in Congress now, I know there was one today by Senator Hawley to create basically kind of a Glass-Steagall type act just for Amazon, in which they cannot sell their own products on the same platform that they manage, and they can't serve both functions. Wouldn't it make a lot more sense if you're concerned about their line of products that you more stringently enforce intellectual property rights?
All I'll say is that I'm all for enforcing intellectual property rights. I'm certainly not an antitrust expert. I think we've learned, I'm concerned on the one hand about big tech size, and I'm concerned about some of the things that I've seen in terms of censorship. On the other hand, we have learned an awful lot in antitrust over the last century, and getting to the consumer welfare standard was a very important, just looking at someone as an outside observer, just a wonderful achievement. Looking from the outside in, and certainly just looking at the Illinois Toolworks case that I saw from 2006, it gives this nice backdrop of like where they came from and somehow treating tying arrangements as bad and those sorts of things, and seeing how that was all based on assumptions or presumptions rather than actually doing the empirical work and looking at how these things have effects in the market. And I think anytime you would want to seek to go away from that, this, what we've built up with the consumer welfare standard, I think is I think you're getting into dangerous waters, and you may have some very bad effects coming out of that as well. And so I recoil at the idea of big as bad being a basis for antitrust reform. It's not. And so anytime you can see intellectual property rights enforced, that's great. I'm a little bit surprised, not a software person, but I was a little bit surprised, more than a little surprised, this Google versus Oracle decision. Goodness, that's code that was copied in a commercial context for a commercial product. I'd like to see those rights enforced rather than creative new ways to have it interpreted not to be enforceable. But that's all I'll say there.
I have to agree with Seth on a lot of that. That my main concerns about big tech lie in different places than whether or not Amazon is selling its own things. And what I like to bring up to my students when I talk about it is, well, Walmart sells Equate brand shampoo, so why can't Amazon sell Amazon branded anything else, to the extent they are not violating intellectual property? But I think a lot of the Amazon based products that are for sale on the Amazon platform have absolutely nothing to do with intellectual property. They're bottles of shampoo, I mean, in all respects. So that to me, I think I don't think intellectual property to solve big tech is the answer for so many reasons, but I definitely don't think that that we can solve Amazon selling its own goods using intellectual property. I think that's just a very small swath of what's going on there.
So to get to kind of the broader point that Seth was, referencing about the consumer welfare standard, and also, it goes down to the core question of, I often start discussions often with students and other lectures that I do by saying, you have two different sides of the debate right now who really dislike tech companies. And I think, conservatives have very good reasons to dislike these companies. I dislike a lot of things that they do as well. And I join them in that, but they're trying to solve a wide array of different problems. So if you look at the left, though, their problem is big is bad. Explicitly, it's not, that they're big and therefore they have power over speech. It's not something that's as targeted or, this list of reasons. It's big is bad, and the ultimate goal is essentially redistribution of wealth or, a whole host of other policy items. So, and that's exactly what antitrust law was like in the 1950s, 1960s, is that eventually it was serving too many masters, so to speak. So, under the consumer welfare standard, you kind of got rid of that system where you could implement any other like policy objective that usually you would, change by altering the tax code or doing, passing some other sort of legislation. This sort of redistribution of wealth, or even for like, environmental law or products liability, there's a long history there, or any other area of civil litigation or complaints that you might legislate. Antitrust is kind of being used for that. And now we've got to the point to where it has more of a specific focus. And antitrust and IP from the very beginning were kind of in their two separate silos, but they did complement each other. They weren't mashed together as one. And we got the Google versus Oracle decision, which I would like the two of you to talk about a little bit about that, and about kind of the dicta that was in both the majority opinion and Thomas's dissent that was related to competition.
Well, I'll kind of bag out of that one a little bit. I'm certainly not proficient when it comes to the software stuff. I just simply, as a common sense reader like everybody else, I looked at it, and they go through the fair use factors, and particularly that this is a commercial matter. That was very important. It was important to Oracle. The code that was used was important to Google, and I simply just don't see things the way that the majority of the Supreme Court saw it. That looked like an unlicensed use of the intellectual property rights of Oracle.
Also, not completely in my wheelhouse. I will say one thing that I have always seen in the Supreme Court, coming from their patent cases as well, is a complete lack of understanding about software and what software is. And they apparently think that 12-year-olds write it in their garages all day long and you prosper off of it. Like one of their primary arguments in the complete hash they've made of patent eligibility when it comes to software is the idea that, well, anybody can do it and it's super easy, so we don't have to give you a patent on it. And I think a lot of that comes through with the, well, it's just code, it can be copied. It's, it's incredibly important from a business standpoint, but it's just code, it can be copied, and writing software isn't really hard. And so I think there's just a complete lack of misunderstanding about what software is and its value to companies at the Supreme Court. And I can't recall what case this is, but going back to Justice Stevens, equating software to the role in a player piano has always charmed me quite a bit and made me just think, dang, they don't know anything about the computer industry. But beyond that, I don't have any particular viewpoints, except I think that that's just complete misunderstanding of how software works in the world.
I think that's a really good point. One of my observations too with this and other cases related to technology, some of which I think were decided correctly, some of which were not. Obviously, I don't agree with the decision that they made recently in Google versus Oracle. But with these cases involving technology, they rely an excessive amount too on amicus briefs filed by, particularly by organizations who have a certain view of how the law should operate to essentially accommodate technology. I would call it tech exceptionalism is kind of their philosophy. And sometimes that they arrive kind of at the right outcome through that. I mean, for example, Apple versus Pepper, I think, was very superficially correct as an opinion, but I mean, their reasoning was very sparse, which I mean, there were other factors in that case, and it didn't help that the plaintiffs changed their theories of monopolization before they got to the Supreme Court, and the whole thing was a little bit of a mess. But essentially, they were saying, you pay through your phone, you pay Apple, and then, with Carpenter United States, it was just, here's a cell phone, someone texts me, and then it pings that thing up there. And that's kind of how they end up describing some of these things, and sometimes they arrive at the correct conclusion, and sometimes it goes pretty far awry, particularly in this case. And I thought it was interesting, though, that Justice Breyer kind of went on this side tangent saying, like, okay, well, if there's a problem, then if there's a problem with monopolies, and clearly there is, then there's then IP is to blame. And nowhere in intellectual property doctrine does it ever say that there's a competition problem whenever there's an IP problem or vice versa. And it's kind of like setting up the tracks to be able to make the same argument in the patent side as well, if that makes any sense. We might as well weaken patent rights too, just because there are these large companies that seems to be a monopoly problem. And both, I think both opinions really do overutilize and misunderstand the term monopolization and what exactly exclusionary conduct is, and are really way out of their wheelhouse and kind of making the implications they're making, even if it's just in dicta. So we only have 5 minutes left. Do either of you have any brief concluding remarks?
Yeah, I can do that. Just housekeeping matter. When I blanked a few moments ago about the Copyright Office and its rulemaking authority, and I was talking about Section 1201. Every 3 years, the Copyright Office proposes rules for exemptions from the copyright law's anti-circumvention provision. And it's very important in this economy. It's a digital economy. A lot of the services we use, like HBO Max or whatever streaming service, Spotify, we're getting access to copyrighted works. And that's a little bit different because we're not actually buying copies themselves. And so it's important that people get access that way, but it's also important that the copyright owners be able to control who gets access so they can monetize their work and continue to put it out there in the market. And the Copyright Office has a little rulemaking thing it does every 3 years about certain kinds of practices or actions that are exempt from that law for certain reasons. And another important function that it does, of course, is preparing studies on copyright law and copyright prospective reforms. And I recently published one on reforming of the Digital Millennium Copyright Act. I think much of it, what it has to say, is good. I don't think that any members of Congress should feel bound by it if they want to go further, as I think they should. The other housekeeping thing is I recently wrote a short little paper discussing a lot of what I said at the outset at our website, freestatefoundation.org. And that paper is called "The Property Rights View of Copyrights Beats Bogus Monopoly Talk." And, if I could just say one more thing, I'm not a super high authority. I like to quote historical people and figures because they have a lot of gravitas. And I think this distinction, again, above what we mean by monopoly is very important. That's what part of this whole triggered this whole event. I think the distinction was well put in a judicial opinion by David Brewer in Budd versus New York in 1892. And he said there are two kinds of monopoly, one of law and the other of fact. One exists when exclusive privileges are granted, and such a monopoly, the law which creates alone can break. And so, if the government, creates the monopoly just itself, only the law can break it. But then there's a monopoly of fact that anyone can break. And and it exists where anyone, by their money or labor, furnishes facilities for business which no one else has. And so, if a man puts up in a city, a building only suitable for offices, he's got the only one, that's a monopoly of his business, but it's a monopoly of fact that anyone can break. And if you're going to use the term monopoly, it's in this sense for a copyright. It means you created something in your own efforts, your own labor. Anyone else can do likewise. You're not keeping anybody else out of the market by your own creative ability. Maybe you did a really good product and it might be harder for the person to get in, but there's no legal impediment to them getting there. There's really no major capital measure to prevent you from getting in there. And I think that's very important. And so, Brewer did apply that same kind of reasoning if you go back 5 years earlier into the case from 1897. He applied that in the patent context, basically saying, a patent right doesn't take anything away from anybody. It's something the inventor comes up with. It secures to them their exclusive rights in certain uses, but it takes nothing away. And anyone else's, there are different dynamics in patents, but certainly with copyright. And so, to get the short grasp of what I was saying, again, I have that paper, Property Rights View of Copyrights Beats Bogus Monopoly Talk.
I think that makes complete sense. Private property is definitely a prerequisite for any sort of commercial activity, and that's how it does establish markets. Professor Singa, any closing remarks?
Yeah, just quickly. First of all, Seth's paper is really good. I recommend you read it. But second of all, I think, and I'm not the first person to say this. I think I've heard Judge Michelle say it, possibly David Kapos and others. But I think the important thing to remember here is that a lot of the problems that we're pointing at and saying, oh, that's antitrust, or even, oh, that's antitrust and patent, they're contract problems. And so we're taking a sledgehammer to hammer in a little tiny staple, and don't do that. So focus on the right question and stop assuming everything is an antitrust problem and that patents are bad monopolies.
I could not agree with that more, and that's true of a lot regarding Amazon and FTC versus Qualcomm and the Parler situation. A lot of things is that the solution is in contract laws. So we're out of time today. Thank you all for joining us. This will be available later on our YouTube channel, and you should also be receiving a follow-up email. I'll try to include the link to the video there. I'd like to thank both of our panelists for coming out and joining us today. This is a really great discussion. I had a lot of fun. Thank you.
Thank you.